importers still use the first sale rule for goods from China? I'm speaking today with Dana Watts. She is counsel with Miller and Chevalier. Hello, Dana.
Hello, good to see you, Robert.
Thanks for being with me today. Would you explain, please, for us, what is the first sale rule?
Yeah, it's a rule that's been used by U.S. importers to reduce their overall customs duty burden for almost 3 decades now. And it basically has 3 parts. You have to have a bona fide sale, you have to have an arm's length transaction, and you have to have an export that's destined for the U.S. And the simplest explanation that I can give is when there's a sale from a foreign manufacturer to a middleman, you're using that price for the customs valuation as opposed to the sale from the U.S. importer, which is usually the default, right? If you're the importer, you have to use the value of the price that you actually pay. The first sale rule lets you use an earlier price, a cheaper price, which means that when you pay a percentage of tariffs or duties, you're paying lower duties because it's lower.
Okay, so that first sale is from who to who? From the original manufacturer to you, or the manufacturer supplier to the manufacturer? Who exactly?
Yeah, sometimes these transactions and supply chains, as you well know, can have many, many middlemen.
Sure.
It can really be anywhere in there, except it needs to be earlier than the final sale to the U.S. importer. The simple example is from a foreign manufacturer to a foreign middleman.
Mm-hmm. How much, I don't know, percentage-wise or however you want to quantify it, does an importer stand to save by invoking the first sale rule?
Yeah, it depends on the markup of your particular goods and your particular industry. For those that have a pretty high final markup, using, for example, the manufacturer's price can mean that you save a substantial amount. Maybe it's 20%, maybe it's more.
Mm-hmm. It's pretty significant then. I take it then it's been a standard practice in importing goods from China then, all along for all this time, correct?
It's become a lot more in use since the Section 301 duties started being imposed on Chinese goods in 2018. The first sale rule can save importers money, but because most U.S. duties are under 5%, a lot of importers have viewed it as not worth their while prior to 2018 because the duty savings was not large enough. Since Section 301 has imposed duties of up to extra duties of up to 25%, a lot more importers are finding it worth their while to use the first sale rule and other tariff mitigation strategies to help lower their customs burden.
Seems like a pretty big loophole that I would have thought that in imposing these tariffs in the first place, that the U.S. government would seek to close. That was not, in fact, the case.
They believe it's fair that the standard rule for customs is the transaction value. So it's usually that your duties are based on the price that you pay for the goods. And basically, if you can show that that the price that was fair in an earlier transaction and that the goods were destined for the U.S., that's the tricky part for a lot of importers. But if you can show that, the U.S. government views that as not being a loophole.
A ruling by the U.S. Court of International Trade called Meyer Corp versus U.S. So that had some impact on the first sale rule. Could you please explain what that was all about?
Yes, it certainly got the trade industry, the trade law industry buzzing. There was some language in this decision where not only were the 3 factors that I've just mentioned discussed to see whether the first sale rule could be used in this case, which are the bona fide sale destined for export to the U.S. and arm's length transaction, but the court seemed to impose a 4th rule, which is the absence of any non-market factors that would influence the price. The court gets this language from the seminal ruling in this case, which is a 1992 ruling for some subway cars made by a Japanese manufacturer that ended up going to the New York Transit Authority. And that was sort of the seminal ruling that set forth the rules. And it does have that language in that case that says arm's length sale and absence of any non-market influences that affect the legitimacy of the sales price.
What do they mean by non-market? What types of things might that be?
Sure. So things like subsidies from the government, in this case, the Chinese government, other things that make an economy a non-market economy. China is, of course, the big one, but the U.S. also considers Vietnam to be a non-market economy.
So this fourth consideration, this fourth criterion that seems to have imposed by the U.S. Court of International Trade, that hadn't been done before. That was not part of the decision making or the factors relating to the first sale rule up to that point.
That's correct. There have been a lot of customs rulings, which are decided by U.S. Customs and Border Protection. They issue public rulings about whether a particular company in a particular situation can use the first sale rule. Sometimes these decisions get appealed to the Court of International Trade, which is who issued this Meyer decision that you're referencing. But a lot of times they're decided at the CBP, at the administrative level, and it's not language that's been discussed, at least not in this way, but previously, not since 1992.
So has the Meyer decision had an impact on other companies seeking to invoke the first sale rule and thereby preventing them from doing so?
Not yet. The trade bar is certainly looking closely at all CBP rulings that have been issued to see if this language will be repeated and if this sort of rationale that seemed to be used in this case will be used in future rulings. So far, no, but there haven't been any cases for sale for China or Vietnam since this ruling was issued on March 1.
Because I would think, I mean, if China is being defined by the United States as a non-market economy, I know that's a point of contention, certainly. But if that is indeed the case, does that not mean that the Meyer decision could be invoked in any case of imports from China, theoretically?
That's the question.
Okay.
But a lot of myself and a lot of other trade lawyers view the Meyer decision as, although it has some pretty strong language in there, what I personally think is that this case was really decided that the court decided this wasn't an arm's length transaction. The government had a hard time getting financial statements that could have helped show that it was in fact an arm's length transaction between with the parent company of the importer. And a lot of the trade bar, and myself included, think that that's really the reason that this particular company, that this particular transaction failed the first sale test, as opposed to China being a non-market economy.
Should the Biden administration roll back some of the tariffs that were imposed under the Trump administration, the 301 actions and the like? And my understanding is, to a great degree, it hasn't so far. But should that happen, do you believe that importers will revert back to just standard calculations of the value of goods, or will they continue to invoke the first sale rule going forward?
It's a good question. The reason importers usually don't use the first sale rule is because it's a lot of extra paperwork. There's already a pretty high burden on U.S. importers to have a lot of documents. They have to make classification and value and country of origin decisions and report those using reasonable care to customs. Adding a first sale transactions means that they now have to keep sales contracts and agreements and shipping contracts, a lot of documents that they wouldn't necessarily have to keep, and they have to be able to justify that decision. It is more work for the importer.
Now, I just wonder, though, if they've gotten used to doing that, they've got the process going within their particular companies, why not just keep it up?
Yeah, I think that's the calculus that a lot of companies are going to make. Although if not for the Section 301 extra up to 25% duties, it wouldn't have been worth our time to do it. But now that we have this in place, even with regular tariffs, regular duties, it makes sense to keep going.
So what should importers be doing in terms of buckling down and preparing for the next big shock, or addressing CBP inquiries on these issues? Do you have some advice for what they need to be doing right now?
Yeah, absolutely. Anyone who's using the first sale rule for products from China or Vietnam should make sure that all their paperwork is in order. They may consider, even if they haven't before, getting a ruling from customs or otherwise vetting their first sale rationale with customs. They should also be thinking about other tariff mitigation strategies, including possibly duty drawback, including thinking about possibly sourcing from countries other than China, and a whole host of other tariff mitigation strategies.
Yeah, there you go. That last one seems to be a big consideration, but the degree to which it's actually happening is another matter entirely. Do you believe that importers are going to be making some kind of a market move toward resourcing either from other parts of Asia or the Western Hemisphere, Mexico, even possibly reshoring back to the U.S.? Do you think that all the entanglements that have happened as a result of the U.S.-China trade war might actually cause this to begin happening?
Yes, as you mentioned, there have been a lot of things there, and the tensions between the U.S. and China they're high right now, and they're being shown on a lot of different fronts. So I do think that a lot of importers have already shifted things out of China to the extent they're able to, and importers that haven't yet made the move are contemplating it. And I do think it's something that all importers should think about.
Dana Watts, thanks for getting into the weeds with me on this topic. I know it's not, you don't consider it weeds because it's your everyday business but from the standpoint of importers, they may not be privy to some of these subtleties of how to reduce their tariffs or how to get around them or what to do in the case of them. But thank you very much for being with me today to explain these subtleties. I really appreciate it.
It was my pleasure. Thank you.